Hello everybody, my name is Advocate SHIVAM MISHRA and I am advocate practicing law Uttar Pradesh. Recently, I argued a bail related matter in district and session court and court finally grant me bail in favor of my client. Actually, about the case fact, my client was languishing in jail last 8 months and this was the second bail application in the district and session court I moved. The first bail application was cancelled, was dismissed by honorable court, but after the charge sheet comes and court frame the charge against my accused, then I make my second bail application in the court and then court grants me the bail in my client favor. But when the court passed the order in favor of my client, he has observed his observation towards the bail order. I would like to share with you. The first thing that court observed, that considering the fact and circumstances of the case, actually it is a generally not new things, nature of accusation and severity of punishment in the case of conviction and nature of supporting evidence. Court also observed prima facie satisfaction of the court in support of charge. But one thing that court observed, that was the reformative theory of the punishment. The court observed the reformative theory of the punishment and larger mandate of Article 21 of the Constitution in India, the dictum of apex court in the case of Dattaram Singh versus State of UP, I think 2018, that was the case law. And court also mentioned, this was the thing actually, when the argument was going on, I was focused about my client. Actually my client have long criminal history towards the ATM cloning, like as 406, 420 and some IT related 66 IT Act, 67 IT Act. This was a ATM cloning related allegation was against my client. So the client, that things which I during my argument I focused that reformative theory of punishment, because I put these things. This is a new year 2022. As we make a new commitment, as we take the new target, as we forget many mistakes, as our life is going on a progress things, we take some commitment. So I during the argument I focus, and court also mentioned that reformative theory of the punishment and the presumption of innocence, that is the basic principles of criminal justice system. And Dattaram Singh versus State of UP and another, this was a case, that's a great case. And court, while the court passed the order in my favor, court also mentioned the judgment of the Honorable Supreme Court, and as usually court do that, without expressing any opinion on the merit of the case, the judge find it to be a case of failed.